Honourable Heather Roy.
Thank you, Mr Speaker. I rise to speak to this first reading of the Police Storage of Youth Identifying Particulars Amendment Bill. The ACT Party is supporting this bill, Mr Speaker, and although I frequently agree with the principled points that the previous Green Speaker makes about urgency and about parliamentary process, we don't believe in this particular case, Mr Speaker, that there is any sinister intent here at all. My understanding is that the Policing Act 2008 contained a drafting error that removed the police's ability to retain fingerprints and photographs or identifying particulars of youth as they previously could under the Police Act 1958. Prior to that era, youth identifying particulars could be stored for young people where a youth court made an order under section 283A through N to the Children, Young Persons and Their Families Act. The era has meant that youth identifying particulars can only be kept for young people when an order is now made under section 2830 of the Act. It certainly was intended that the provisions for retaining youth identifying particulars in the Police Act 1958 be carried over into the Policing Act 2008. And this bill that we have before us today in the House merely seeks to reinstate those provisions. I recall when the Policing Act under the stewardship of the Honourable Annette King was being moved through the preparatory work, I would have to say that the then Minister of Police consulted very widely. I remember several occasions when she made her officials available to opposition MPs, such as myself, and a number of issues were discussed, and I think that it was a genuine oversight in the drafting of the legislation. That's not to say that we shouldn't be more careful about ensuring that everything is absolutely right, and the Honourable Annette King, in fact, has made that point herself in the House this morning. So there is a degree of regulatory responsibility we should be very cognisant of. But it is totally unacceptable, Mr Speaker, that we should have the police acting unlawfully, and this bill is very much needed. Given that the intent was always that this provision would be in the 2008 Police Act, I would on this rare occasion actually say that urgency is being absolutely appropriately used. It's important that this is rectified as quickly as is possible. We have heard from other speakers that the police have collected youth identifying particulars for around 2 years unlawfully, as they were unaware that there had been this legal change, and this situation does need to be rectified, as I've said, very quickly. This bill will not extend, and this point is very important, this bill will not extend the police's ability to collect or retain youth identifying particulars beyond what the 1958 Act intended. So in essence there is no change at all in the intent of collection of these identifying particulars of young people. It is merely rectifying the legislation and putting in place the provisions that were intended and should be there quite rightly, and the ACT Party will be supporting this bill.
I call the honourable member